Good afternoon and welcome to today's webinar, 3 High Liability Issues with the Management of Special Needs Students. During today's webinar, our presenters will cover the following: lack of accurate understanding of federal law regarding special needs education, safety issues, management issues, poor management of students, the real problem. The presenters for today's webinar are Dale Yeager and Andy Demidont. Dale is the president and CEO of SERIF, a consulting and training firm. SERIF offers corporations, schools, colleges, hospitals, government agencies, municipalities, law firms, and individuals a vast array of programs to solve problems. In 2000, Congress tasked Dale and his expert team to produce a State of School Safety in America report. Since being tasked with authoring that report, SERIF has provided 3 reports to Congress. Dale's research work on school violence has been published in the FBI Law Enforcement Bulletin and the Texas Attorney General's report on school violence. In 2005, Dale was appointed to the Development Committee for the Fairleigh Dickinson University School Safety and Security Administration Master's Program. Dale and his expertise team have provided school safety training to over 26,000 schools in America. Andy Demidont is retired from the public education system after more than 35 years of service. During Andy's tenure in public education, he held various positions such as assistant principal, high school principal, and superintendent. He also taught graduate education courses at Mansfield State University. Andy has been nominated to serve on a statewide task force on restructuring the education programs in the state of Pennsylvania. He's also the recipient of numerous state and national awards. If you have a question that pertains to the presentation, we ask that you use either the chat feature, which is found on the right-hand side of the screen, or the Q&A feature, which is found below the chat feature, to submit your questions. Our presenters will do their best to answer your questions throughout the presentation. Please do not be shy. The questions really make the presentation, so please feel free at any time to submit a question to me and or to the presenters. Approximately 1 hour after the event, we'll send out an email with a link to the archived recording of the webinar. This email will also contain the PowerPoint slides used during today's presentation. We do ask that you take time to fill out the survey that will appear on your screen after the webinar is over. Your comments and feedback are important as we develop these webinars. I invite you now to sit back, relax, and enjoy. I'm now going to turn it over to our distinguished presenters, Dale Yeager and Andy Demidont. Dale, it's all yours.
Thank you very much, Matt. Greetings, everyone. I know today we have attorneys, we have superintendents, we have a variety of people who both work with school districts as well as attorneys who have actions or contemplated actions against school districts. So we will talk to both sides. That's our job, to stay in the middle in this presentation and give advice to both sides. But today's presentation is called Liability in Special Education, 3 High Liability Issues with Management of Special Needs Students. As I go through these slides, one of the things I'll do is make a brief statement about each category, and then Andy will give the details or the commentary on those specific issues. And again, if you have a question, type it in, and we're going to answer everyone's questions. We'll stay here until they're all done. There's usually about 40 minutes worth of questions, so the presentation we're going to try to get through it as quickly as possible, but make sure we cover everything. Let's first talk about some facts. The U.S. Department of Education in 2009, in their estimation reports, which are very accurate, estimated that over the next 5 years, 60% minimally of all K-12 students will be special needs. This is a huge, huge issue. Many of you have read news reports or watched news reports on television about the increase in autism and the causes of that. Bottom line is, this is not going to go away. It's going to increase. In fact, my degree, my bachelor's degree in education really isn't effective anymore. It's not valuable anymore because I got it back in 1980, and now to be a teacher, I would have to have a double major in both education and special education. And many universities realized this several years ago. If I remember correctly, Andy, St. Joe's was the first to offer the double major. And so education is radically changing, as all of you know, and this is really the key in that change. And so we're going to talk about that today. The fastest growing student disability is autism. There are 7 types. Asperger's syndrome is the most common, and it is the mildest form. Most famous person with Asperger's is Dan Aykroyd. Most people don't know that he has it. It's what kept him out of law enforcement. That's what his desire was before he went into acting. So it's a very common form of autism, but there are different types and they have different manifestations. We'll dip into that as much as time allows today. Juveniles account for 1/3 of all sex offenders. Female juveniles are the fastest growing group for sex offense. In the last 10 to 12 years, the Justice Department has tracked that of sex offense by students in a school environment, the majority of those sex offenses are in special needs classrooms. And we're going to talk later about the causes of that, because what I do as a criminal analyst, I work on criminal cases and I train federal law enforcement on the issue of sex aggression by youth and adults. And this is a statistic that scares people and most people don't know about, this issue of juvenile sex offenders. Yes. Andy?
Before you leave the slide, let me just kind of interject a couple points here.
Sure.
The first one, the U.S. Department of Education's estimates. Some of you may have been involved in our most recent webinar on special needs students and the issues related to transportation. And at the closing of that session, I made a forecast. And it's a forecast that I have made as an administrator probably for 10 or 15 years. And that forecast essentially is that, in my opinion, in the next 5 to 10 years, virtually every student in this country will have some form of a IEP or something similar to that. It may not be called an IEP, but it will have something very similar. Secondly, as far as the disability and autism assessments, it has perhaps created some of the most difficult situations especially for students with Asperger's disease. Because as you well know, a student with Asperger's may be very high performing in certain areas, yet still very difficult to deal with. And the pressure that places on administrators in schools across this country is extraordinary, because if some of that behavior manifests itself in outbursts or in what some people perceive to be violent behavior because of flailing or whatever may manifest itself for a student of that sort, the pressure on schools to isolate those kids is extraordinary, and to get them out of the building from parents. And school people need to be fully cognizant of procedural safeguards for a student of this type and what the impact of the manifestation, determination, and the behavioral assessment that may follow present for a student like this, which may mean the student stays put, which puts the onus and the bullseye on the administrator who makes that decision in the pressure from parents. You're not protecting our kids, you're allowing violence, when in fact none of that may be true, or at the very least, there's very little that the administrator can do because of many of the state put provisions that are in existence when it comes to special education. So it's an area that, on top of everything else that school administrators in this day and age need to be responsible for, is an extraordinarily difficult one on both facets for the classification of students with special needs, and in particular in this area, autism. And also with another area that we thought about putting in here as one of the high frequency ones, and that is ADHD, okay? And how that oftentimes is being misinterpreted, and how the evaluations are oftentimes being misinterpreted with a simple checklist, when in point of fact, there is only one real valid assessment, and that is a neurological exam performed by a neurologist that can determine that particular behavior. But absent that, we have a tendency to use checklists. And so you see a proliferation of the number of students who fall into that category as well. Thanks, Dale.
Okay. Next, lack of accurate understanding of federal law regarding special education. For those of you who already know this stuff, we apologize, but we want to make sure that we educate everyone and talk about these specific issues. First and foremost is IDEA, Individuals with Disabilities Education Act. Staff and administrators, in many cases, are unaware of changes in discipline rules. We're in thousands and thousands of school districts in the United States. And one of the things we do when Andy and I are training administrators, social workers, psychologists, school counselors, we question them. We do a test to see what they know about the current changes in these federal laws. And it is surprising, I guess not surprising anymore, but it should be surprising to most of you, that the majority of them, and I would say majority means 70% across the board, do not know about the specific changes that have occurred. People are not reading their Department of Education bulletins that are coming out. Many of them are not subscribed to them. And this is a problem because this is going to create a liability issue, a big liability issue. And understanding this law and its modifications and understanding what is required by federal law is critically important. And so, Andy, would you like to talk about IDEA just briefly?
I just want to mention a couple different areas that kind of represent and personify the issues that Dale has spoken to. And one of them deals with the development of the IEP. Throughout the history of education, IEPs have been developed in a manner that this most recent change was meant to address. And that manner goes something like this. And for those of you in school, again, I apologize, you probably know this. The school staff or the IEP team, from the school's perspective, gets together, develops the strategies or a series of strategies, brings the parent in, and presents the parent with those particular strategies that they have come up with. Under the new regulations, the intent of the law was to have the parent as a viable partner, and in fact the student in some instances, especially the student, if it involves his or her transition plans, transition from secondary school to post-secondary education, that they be part and parcel of the development of the plan. And yet what we see many, many times is still that the school is off on its own, developing it. Once it's developed, they bring the parent and say, this is what we think is best for your kids. That was not the intent of the law. One of the other areas that schools oftentimes mistakenly involve themselves with is once a student's IEP is developed. For those of you, again, in education, you well understand that one of the worst things that can happen if you're getting a compliance audit is for a compliance auditor to come to your school, go about your building, and as you well know, oftentimes they will pull selected files randomly, and they will go around the building and check with particular staff members to see if they are aware of what a particular student's exceptionalities are and what his or her IEP calls for. We again see all too often that schools and staff members responding in a manner that essentially exposes the school to very significant problems. And that simply is, I'm not sure. I can account for situations where compliance monitors went out to a physical education site, interviewed physical education teacher and said, do you know what Andy Demidont's IEP says? Worst answer in the world, no idea. The kiss of death for a school district. It exposes that district to so many different issues that we really don't have time to get into them today. But you can well imagine what is done. Another area that is extraordinarily misunderstood is the presumption that special ed means I cannot discipline a child in the manner that I would discipline a normal student. That is absolutely, absolutely not the case. I can discipline that particular student in a normal manner as long as he or she has had a manifestation determination assessment and, if necessary, a behavioral assessment. Those are requirements. And many people then misunderstand what that means. Let's assume for a moment that the student is indeed, his or her exceptionality is indeed determined to be by the IEP team and the entire representatives of that team to have his or her behavior as a characteristic of his exceptionality. The assumption is if that student commits a particular breach, a serious breach of school conduct, that the state put clause is absolute, and it is not. I can remove that student for 45 days to a placement. Within that 45 days, I have again the opportunity to make the determination, manifestation determination, or, if necessary, make an adjustment to a behavioral assessment plan that's been put in place. At which point, I also have to give the parent the option of a due process hearing. The due process hearing is, as most of you again well know, pretty well spelled out as to what the requirements are and what the notifications are. But a hearing officer may still determine that the change of placement is appropriate, irrespective of whether the finding is that the student's behavior was a characteristic of his exceptionality or not.
Andy, I want to add something to that. Those of you who are administrators or attorneys who represent school systems, I'm going to say something to you, and then I'm going to say something to plaintiffs' attorneys who have actions or contemplated actions against school systems. If you're an administrator, it is critically important that you have a yearly assessment, an outside assessment of all of your special education, how it's run, how it's managed, because the things that Andy is mentioning is a management problem. It is a management issue, and one of the things that we say at Seraph is that school safety is a management issue. It's not an equipment issue; it's a management issue. And these lawsuits, these litigated situations that come up time and time again, we've seen it for 20 years because of a lack of management, which includes communication, which includes someone specifically being in charge of knowing what's going on. And there's a lot of people assume that Mary knows or Tom knows, and that's no way to run the department. The second thing I would say to those of you who are plaintiffs' attorneys, it is critically important that you understand, and obviously you're here and you're hopefully getting this. This is a complicated issue, and there's state law, there's federal law, there are management issues, and this is important that you have assistance in understanding this complicated issue if you're representing someone. And so it's critically important, very, very, very important. But the last thing, and I want Andy to say something about this last piece, which is local school policies that violate state and federal laws. Andy, how many times do you and I both see this on a regular basis all over the country in both urban, suburban, and rural school districts? Andy?
All too frequently, because what happens is that schools rely on template policies and procedures that do not get updated with the frequency that they should, and most importantly, oftentimes their policies and their policy manuals are inconsistent with what their student, parent, and teacher handbooks call for. And it exposes that kind of inconsistency, as most of you who are attorneys and school people know. Those kinds of inconsistencies are an open door for major problems. Can I just finish the clarification of that 45 days?
Absolutely.
Everyone pretty much knows that possession of a weapon or sale and distribution of drugs on school campuses can kick in that change of placement that I was referring to. What is less known and should be known is the following phrase, which is also attached to that entire section of the law that deals with removal of students with special needs. And it says, any student who has inflicted serious bodily injury upon another person while at school, on school premises, or at a school function are under the jurisdiction of that particular section of the law. The bodily injury part is the one that gets ignored. Everyone knows that a gun automatically triggers the possible removal or the sale and distribution of substances. But what they don't oftentimes recognize is that bodily injury portion also can be used to remove a student from his or her placement.
And
the
let
other
me.
Area that, the other area that the confusion deals with is in many states now, and basically it's occurred as a result of the United States Department of Education's Special Education and Rehabilitative Services Division has asked, and now states require, that prior to placement within a special education program, that a school district be able to amply substantiate the steps that were taken within a regular classroom prior to that student's placement. In Pennsylvania in particular, as a result of the Gaskins consent decree, schools now have two sets of audits in our state. One is the traditional special education compliance audit, but then the second one is as a result of the Gaskins consent decree, which basically says to school districts, you better be able to show, before you considered placement of that student in a special education program, that you had taken specific steps, developed specific plans to meet that student's needs within the regular classroom setting. Okay, Dale.
Okay. One of the things I wanted to say, too, is that this is where the liability issue really goes to a whole new level, is when you have this lack of assessment being done internally in the school district or in the school by professional people who know the subject, understanding whether you're in compliance or not, or if you're in violation. If you're in violation, then obviously everything you do from that policy on, all the management of those students is going to be inaccurate. Their assessments are going to be inaccurate. What's going to happen down the road is that that's going to open you up to lawsuits. And when the lawsuits happen, any good attorney is going to pull those documents in discovery, and they're going to see all that disconnect, and there's really no recovering from that. So it's important to have an assessment, an audit done in this particular area. Next, safety issues and management issues. Special education staff are generally not trained in the emergency management of special needs students. Now, all of you who are parents know, or aunts or uncles or grandparents, when you have a small child, 4, 5, 6 years old, who doesn't want to get off the floor, they may only weigh 50 pounds or 40 pounds, but if they don't want to get off the floor, picking them up feels like they weigh 200 pounds. And the problem is that you would assume, and again, the bad word there, you would assume that special education staff are specifically trained in dealing with special needs students during an emergency, but I will tell you from personal experience, and Andy will tell you, that they are not. Most of them have no training at all, because when we go in and do emergency management training for these schools, it amazes me how many special ed teachers say, I didn't know that about children with ADHD. I didn't know that about children who have autism. I didn't know that. I kind of suspected it, but they're not being trained. So the emergency plans in most school districts in the United States, and I know it's a general statement, but believe me, we have a pretty good sampling that we work from, are inadequate in this area specifically. They may deal with the issue of the child that has immobility or mobility issues and is in a wheelchair. They may have dealt with that, but they certainly have not done very well in schools with taking their emergency management plan and updating it based on reality when it comes to special needs children, because they are going to panic when there is stress, and you're going to need trained people to speak to their unconscious mind to get them to calm down and come with you. You can't speak to the cognitive, because the cognitive is gone, as with most people in an emergency, but especially with special needs children. And so this is a critical area. This is a weak point in schools. Emergency plans are lacking. They are lacking. big time. Policy updates. Now, I put a question mark behind that because, again, how good are your policies? Are they not just accurate to federal and state law, but more importantly, are they specific? I'm talking about safety and emergency plans to a specific building. For example, the Justice Department many years ago found that low ceilings, when there was a low ceiling in a classroom, it actually aggravated aggression in children. It's the same thing happens with adults. And the reason why is because with a low ceiling you feel compressed. Well, all of you out there have been in or seen a California-style school, which is one floor. They were built in the late 50s, early 60s. They have a flat roof, and they have low ceilings in their classrooms. If you have your special education students in a low ceiling classroom, that's a problem. And there's actual scientific data to back that up. The question is this: is your emergency plan, is your safety plan, and they're even worse. Most school safety plans are horrible because no one's ever had a management assessment of the schools, and they're putting these safety plans together with somebody's template. And I will tell you right now, and Andy will agree with me, do not use a template for safety plans or emergency plans. Other than a basic outline, you've got to customize them. And any good attorney, those of you who are attorneys for law, for school systems or administrators, any good attorney is going to look at your safety plan or your emergency plan. They're going to run it through a software program which is available for about $20 for plagiarism. They're going to find out whose plan you cannibalize to make your plan, and they're going to ask you on the witness stand, how does an emergency plan from Oklahoma, how is that relevant to your school in New Jersey? And this is a problem with doing things in a expedient way. You can't do these things expediently. You've got to customize. The building design, the geography, the student size, all of these factors have to be factored in. Otherwise, your emergency plan and special and your safety plan become a liability, become a huge liability. Most of the time, they contradict each other. This is another issue. You've got to assess so that you're protected. Very important. Andy, do you want to say anything about this?
Well, essentially, the areas of training are what I see most often as the problems, along with the plans that you've focused on. The areas of training in particular that are a problem are in the types of restraints that are used. There are many school districts that are still using very overt and strenuous physical types of restraint that are no longer permitted, especially dealing with autistic students and dealing with students who have severe behavioral issues. Okay, and without that kind of training, obviously you as a school district expose yourself to the difficulty. One of the major areas that schools also have a significant difficulty dealing with is inclusion. Inclusion has, depending on where you are, either a good or bad name. What does inclusion mean? Essentially, the long and short of it is, inclusion is putting a special needs student in a regular ed classroom for his or her academic skills. Let's say, for instance, an autistic student who has Asperger's disease and is in a Asperger's syndrome, and is in a regular class but has a very high efficiency rating and performance rating when it comes to mathematics. Okay? In that inclusive setting, what we see all too often is schools trying to make inclusion work, not necessarily because it fits into their overall culture and their overall thinking, but because they think that fundamental compliance looks good. What we'll see is reports that it's not working. Inclusion is not working. It's failing. And invariably, when you go back and you find what has transpired, the inclusive practice was kind of pushed into the school either because of a legal issue or because of some special interest group pushing that agenda, and the school decided, well, it's just easier to incorporate it. And what happens is it promotes more difficulty and problems, A, for the teacher, B for the student, C for the parent, and ultimately for the school district as a whole. Not because inclusion itself doesn't work, but because it was not implemented correctly by providing teachers training, motivational training. Motivational training teachers have had ad nauseum historically. The problem with it, in many instances, they've gone back to their schools the next day after the training and kind of scratched their head and said, what's really in this for me? Because it had no relationship with what they were doing instructionally. It was kind of a feel-good seminar, but it really had no specific impact on what they were doing in their classroom. So what we're looking for when we talk about the training is training in inclusive practices for schools that includes motivation that is focused, motivational skills for teachers to implement lesson plans for students who suffer from various types of special needs classifications, and then to make that training specific to the subject area that they teach. That training is out there, it's available, but oftentimes it's just, the program is, I hate to use the word pushed, but it's just shoved into the schools, and teachers are asked to make it work with little or no preparation. One of the other areas is inclusion. The long-term benefits have cost benefits to schools. There's a savings. But the initial implementation and adoption of the program oftentimes takes a little additional funds to make it work properly. For instance, that student with Asperger's that I referred to earlier may temporarily require an aid until he or she adjusts to the regular classroom setting. So training is the area that I think is most missing, specific training, not the generalized stuff that many schools are promoting with their teachers.
And let me finish this section by saying this. It's critically important if you're an attorney who has contemplated legal action against a school district, you need in discovery to be asking for the training curriculum, the testing, what the tests are, what the test scores were in that training. Because if you're doing training and you're not testing anyone in something this complicated, then they're really not, you don't know whether they absorb that information or not. You need to be asking for these documents, and if you're a school system, you need to really ask yourself a question. Are we really getting quality people in here to deal with this? And I'm going to tell you something else. As a criminal analyst, the training has to be has to include something in the issue of safety issues, the issues of crimes committed by special needs students, because special needs students have a disproportionate amount of sexual aggression. And this is a critical issue that nobody likes to talk about because it's about sex. But you're going to have to deal with that. And I will tell you that general psychologists and child psychologists generally do not have proper training or experience in dealing with criminal behavior by juveniles and children. That is forensic psychology, and generally you need a psychiatrist-level person with specific training in forensics to be able to talk honestly and accurately about that. You've got to include that. That's got to be included. And when it's not, most of the cases that we see are about sexual assault by special needs students, either to them or by them. And this is, if you're going to ignore a problem, it will not go away. It will continue. Moving on. Poor management of students, the real problem. The IEP issue. Now, Andy talked about this. Do you want to say some more about behavioral manifestation determination?
Well, I want to talk about the IEP in general, and in particular the IEP team, because it's another area that is oftentimes not clearly abided by. The IEP team, the development of that team and the inclusion of who should be there, number one, first and foremost, the parent and the child. At least one regular ed teacher of the child, and not less than one special education teacher of the child, a representative of the public agency, and that representative of the LEA has to have decision-making capability. In other words, bottom line, they have to have the authority to spend money if needed. An individual who can interpret instructional implications of the evaluation results. Usually that's a school psychologist, and at the discretion of the parent or agency, other individuals who have knowledge or special enterprise regarding the child, related service personnel are appropriate. And whenever, in particular whenever here, refers to transition development, the child with special needs themselves. The other aspect of that is there is a presumption that everybody has to be there at all times, every time the IEP team meets, and that not having, let's say, for instance, a regular ed teacher participate on a particular occasion is a violation. Not necessarily. As long as the parent signs off, key word, signs off on that person's absence for that particular meeting because he or she may not have anything to say about the particular topic at that particular juncture, that individual can be excused from the meeting. That goes back to the training issue that Dale was talking about previously, and I want to touch on that, Dale, before we get too far away from it.
Sure.
As a school district, if you have training, I know it's a pain and I know teachers squawk about it constantly. What's equally important is for you as a district is to have documentation that verifies the teacher was there, that the teacher evaluated and had an opportunity for feedback as to the training, and that you have a record of attendance at that particular training. Because all too often what we see is, yeah, we had that, but you know, Andy was absent that day, so he never got it. Is there a way then that you have at systematically providing follow-up for those people who missed that particular training? The behavioral manifestation determination I've talked about several times, but essentially people mistake the order, okay? The first thing that takes place is the manifestation determination assessment. Once that's done, the purpose of that particular process is to establish whether or not the child's disability has a direct relationship or correlation to the misconduct that he or she is being accused of. If, in fact, the IEP team determines that it was, in fact, a manifestation of his or her exceptionality, the second phase comes in, and that is the behavioral assessment. Once the behavioral assessment is done, the third piece comes into place is implementation of a behavioral assessment plan, and then communicating that plan to all of the teachers who are going to be responsible for that particular student.
Excellent.
That leads to the next heading, Dale, because you have the information disconnect.
Correct.
That's the information disconnect that I'm referring to. It really is three parts. And if you've been in schools for any length of time, you know for those of you who've been in for 20 years or more, you know the volume of what is expected of you has proliferated in leaps and bounds. What you're expected to know. You're expected to be a legal expert. You're expected to be a special ed expert, a psychologist, and all of those things. I realize the difficulty therein, but for administrators that are in the audience, yeah, there has to be a way for you to systematically to be made aware of the updates that occur to IDA or to federal and state statutes. Secondly, when that information gets to you, to have a systematic way of making sure that all those who need to know it are informed of it and have a way of identifying that they've received it, and you have that in your file. Lastly, the teachers again, and it's always probably the reverse order because they should be the first ones to know this probably, to make sure that the teachers are aware of what's expected. Go ahead, Dale, I'm sorry.
Okay, no problem. All right. I'm going to talk about this next segment, and then Andy can pitch in some information on it. 4 assessments. Now, I hate to take everybody back to college psychology, but there has been a problem in the U.S. and Canada in specifically with various schools of psychology. And the problem is that much of school psychology is really based on Carl Rogers and Maslow. You remember those names. And the problem is that those views of psychology are very prevalent in schools among school psychologists and counselors and among education professionals. And that disconnect causes a problem, a liability issue, when we're talking about special needs children. And let me go into the 2 categories that I want to talk about here. First is a physical disability, and the second is a personality disorder. Now, as a criminal analyst, I deal with people with personality disorders. You may know them as sociopaths and psychopaths. Now, in children, we call that defiance. It's still psychopathic or sociopathic behavior, but we use the term defiance. And there's various types of those. A personality disorder is a learned behavior. It's a reaction generally to childhood trauma, but it is not necessarily a mental disability or some kind of a defect of the human mind in the case of ADHD or autism, where you have a lack of development of the brain. So it's important to understand as school administrators, as school attorneys, and as attorneys, plaintiffs' attorneys who are going with actions against school districts, to understand the difference. One of the key questions that never comes up, and I'm speaking here to attorneys who take action against school districts, one of the key questions that never comes up in a discussion about a student who has committed an aggressive or violent act is what part of their behavior was cognitive. Cognitive, as all of you know, is the conscious mind, what we're all using right now. It's the decision-making mind. And by the way, cognitive function is not affected dramatically, as many people believe, by a lot of outside influences like alcohol and drugs. In fact, there's a lot of debate about that. And in forensic psychology, there's a lot of evidence, research evidence, that says the cognitive function is still relevant. It's interesting that people who are schizophrenic know the difference between right and wrong at least one time every day, and they have a mental disorder. And so if they know the difference between right and wrong, which is certainly a legal status in a criminal case, certainly children do, depending on their age. And so the question is, what part of this behavior is cognitive? And sometimes the standard psychological view of these disabilities needs to be challenged, because a personality disorder is not necessarily a mental disability. Now, there can be both. Some children have both or multiple manifestations. But it's critically important to understand that. Now, why do I bring this up? For several years now, for the last 3 years I know of, the Department of Education has debated aggressively and has made plans at some point to separate children with physical and mental disabilities from children with personality disorders. And so at some point, we believe, Andy and I believe, based on watching what's going on in Washington, that they will be separated, and that at some point the federal money for handling children with personality disorders will dry up. But the key thing is the issue of inclusion. It's very, very important that you ask yourself as administrators of the school district and as attorneys who represent school districts, how well trained are your staff, not just special education staff, but general staff, in handling kids who have defiance, who have personality disorders. This is a critical question, and professionals should never be scared to assess themselves or ask tough questions. And so while this sounds very complicated and psychological, it's important because Andy had mentioned a few moments ago about the need for a doctor to assess certain disabilities, a psychiatrist, a medical doctor. And many times this is not being done. It is an ongoing battle for many years between psychologists and psychiatrists over who should have dominance in the field. And so you need to know about that professional conflict that goes on between them, because it certainly is manifesting itself in schools as we see it. Parents and disability assessments, not my child. This is a constant problem that we see. We hear it from school psychologists, we hear it from administrators, we hear it from principals. The bottom line is that many parents, and there are certain categories, but many parents are reluctant, if not defiant, when it comes to teachers saying, your child has a learning disability and we'd like to get them evaluated. And what happens is the parents think that the teacher is picking on their child, or they just don't want to deal with it. They probably know that the child has a problem, but they don't want to admit it. Sometimes ethnicity plays a part in this. We see this with recent immigrants to the country. So this is a critical issue, and this requires good management, good policy, and good training to deal with this issue. Because a lot of times these kids are not getting proper care. They end up committing a crime, many of them do, and now you have a lawsuit on your hands because there was no professional assessment done, or there was no way of dealing with the parents, or the parents were not being dealt with or included in the process to determine what their child needed to handle their problem. And this goes back to something Andy talked about. It is required by law to have a parent or a caregiver involved in this process. And this is, by the way, as a school district, one of the ways you avoid litigation is include them in the process. And as attorneys who take action against school districts, this is a weak point, not including the parents in the process. But Andy, would you like to talk about this particular issue?
Yes, I would. In particular, what you were just addressing there in terms of parental involvement. The requirement is there, and the burden is really on the schools. You know, what you hear many times from school is, well, I've called the parent and they don't want to come. Okay? Here, what the best advice for school people is very simply this. Make sure that you made multiple efforts. Make sure you made diverse multiple efforts. And make sure you documented them to invite that parent to participate in the process. That's your best safeguard to make as a school district, to make sure that that parent has had every feasible opportunity to be invited to participate in his or her child's IEP. You know, obviously, although I haven't heard in some jurisdictions where local magistrates have essentially ordered parents to attend an IEP meeting, you know, but that is not very prevalent. So the best advice for a school is make sure you have as many particular steps documented that you invited the parent to participate in the process. If I can, just a couple other things that...
Okay, well, Andy, we do want to allow questions, so I'm sorry, but keep it brief. We're running out of time.
All right, I just want to touch upon what happens if there's a disagreement with the manifestation determination between the parent and the school. The presumption oftentimes is that that is an impasse and nothing can be done. The school has the authority to go ahead and act. The parent obviously has then the option to pursue recourse through a due process hearing or mediation. Most states are trying to push mediation as a first recourse. I don't know how successful that's been, but that's an option. The other question I wanted to address is, you hear all the time is, do I have to hold a manifestation determination hearing every time I change the kid's placement for 10 consecutive days? The answer is an unequivocal yes, you must. Anytime you change placement 10 days, 10 consecutive days, you must have it. Does a school need to conduct a manifestation determination when there is a violation, like we had spoken to earlier, a weapon, sale, distribution of drugs, or of serious bodily injury? And again, the answer is yes. You're required to do that. One other thing that I wanted to touch on that perhaps I did not make clear. Students are oftentimes referred for special ed evaluations. let's say that student goes through the process with the parent's consent, and it's determined that he or she is not eligible for special education or related services, okay? One of the things that you need to keep in mind, if that student later becomes a problem, a serious problem for behavioral reasons, that student may invoke all of the protections that a special needs student is entitled to. Having said all we did here in this short period of time this afternoon, one of the things I want to make clear to you, and it goes back to the inclusive practices, you can, as a school district and as a community, and I think as a nation, avoid a great deal of difficulty in addressing the needs of special needs students and, in fact, your regular students if you provide, Dale had mentioned this, not only your special education teachers, but also your regular ed teachers with the necessary requisite skills to address the specific needs and exceptionalities of the students they're being asked to teach today. One of the areas that is most frequently missing is that type of preparation. The lip service structure is there for those kinds of programs in many school districts, but the building blocks and foundations are not put in place. And along with the qualitative aspects not being there, it exposes that school district to enormous potential liability. That's it, Dale.
Oh, okay. All right. What I'd like to do now is take a couple of questions. We'll stay on and answer all of your questions. So, are there any, Matt?
Yeah, I have two questions from Nellie, who asked, I recognize that we're unable to use someone else's plans. Are there any plans out there that you would recommend to use as a guide?
Well, okay. Again, no. You have a basic outline. When we work with schools, we have a basic outline of things that need to be in a plan. First of all, you have to take the existing plan you have and you have to have it audited and you have to have it assessed for contradiction, for compliance with federal and state law, and just practicality. Secondly, after that's done, then you're going to have to edit that plan and have it edited, and you've got to include a lot of people in that process. It can't just be done by one person. There is nothing out on the market today that you can use that reduces that liability factor. Any good, smart attorney is going to look at that and say, wait a minute, you took this template and you plugged and played, but the problem is that you left out this or this or this, which is critical to where you're located physically. Again, a basic outline filled in properly from a proper assessment is the only thing that's going to, number one, prevent liability issues, but more importantly, really protect your staff and students. There is no simple solution to this problem. It's got to be done customized, and there's manpower involved. Some things technology cannot solve, and this is one of them. So, any other questions?
Can I expound on that a little bit quick?
Absolutely.
The key word is guide. There's a difference between using something as a guide and then what we see most frequently, or all too often, is what was supposed to be a guide substitutes for the actual document in that particular school district, and that's where the holes are. The Office of Special Education and Rehabilitative Services in the United States Department of Education has a variety of documents available that are guides, and they are meant to be guides, and they're stated so specifically. The National Education Association has guides. Almost every State Superintendent's Association, State Principals Association has guides. In many states, the statewide organizations that deal with special needs parents have guides. So there are many guides. They are intended as guides. That's not what we're saying is a bad course. What we're saying is to take the guide and substitute your name for it and call it your own. That's where you're going to get yourself in trouble.
Any other questions, Matt?
Yeah, we have another question from Nellie, who asks, Regarding training, we follow and attend our ESC recommendations. Sometimes it appears not enough. So which trainings are considered a high priority in the area of special ed?
Andy?
Well, the one that comes to my mind most frequently is, especially if you're utilizing inclusive practices within your school, is providing teachers with instructional skills that allow them to work with students by exceptionality and by subject area. That's the area that we see very, very deficient. And the second area is how to effectively intervene with students who have various types of exceptionalities. The two that we've been talking about, ADHD and autism, come to mind most frequently right now. But that's where we see teachers struggling. You know, how do I motivate these kids? How do I address the behavioral issues within the classroom? Now, our basic philosophy and premise is the best type of behavioral intervention is an instructional one. So I go back to the first area that I just addressed, and that is provide teachers with the wherewithal to design lessons. By training, if you understand training in most cases, for many of the veteran teachers out there, they were taught a subject, math, science, social studies. Special ed teachers were taught intervention skills, instructional strategies. The two need to be brought together for an effective inclusive practices. And that is again, essentially what Dale has talked about earlier, that many colleges and universities, probably because of NCLB, special ed teachers in most situations are not considered highly qualified under NCLB. So many states now are requiring a dual major that Dale had spoken to earlier. And many universities have stepped up to the plate and understood that. But if you have a veteran staff, many of them did not have an opportunity to get that kind of instruction. So if I'm planning staff development, and I'm going to concentrate on differentiated instruction in the classroom. I'm going to concentrate on motivational strategies for math, science, social studies, stuff that is specific, not just the generic. We're going to have a workshop on motivation today that everybody after the workshop feels real good about, but then they go back to their class and realize that the next day there's very little, if any, that they can apply to their daily job.
And by the way, let me say something, Andy. Those of you who are attorneys who are listening to the webinar, who bring legal action against school districts, man, in discovery, this is where the long list of documents that you need to ask for is so important to see if all these pieces of the puzzle are in place, because if they're missing, believe me, they have an effect on what happened to your client. And so this is a complicated issue. This is a very complicated, and by the way, every school in America should have a safety team. Many of them do not, or they're poorly trained, a group of staff and administrators who are in charge during an emergency. They have to be trained in dealing with special needs students because they're going to have to help out. When a major emergency occurs, you're going to have to use these safety team people to supplement the special education classroom staff to get these kids out in an emergency. So there's a lot of training that's got to be done on a yearly basis. I mean, you can't just do it one time. Or you have to have a train-the-trainer program, but you've got to get this stuff done. You've got to ask the question. I guess the answer to the question really is, okay, we've met these standards. Now, what else do we need to make it work? That's the bottom line. Matt, are there any other questions?
Yes, there are. There's a question about the information that you provided at the beginning of the presentation about ADD and autism being pretty much the two major issues that you see in schools these days, and it's growing exponentially. What would you say are the major issues that you see when you go into schools with children who suffer from ADD and autism? I mean, where do you see the major issues in schools, and how can you mitigate some of those issues?
Andy?
Well, I'll take autism on. I think I touched on that earlier. The biggest problem that I see is making sure that teachers within the school are aware of that particular student's issues, and to kind of develop an understanding within your school community that your school addresses the needs of all of the students, to make people understand that in many instances, a student who some people may perceive in the community as being violent are really not. It's just a manifestation of their exceptionality. But that there are many more positive aspects that that student brings to the organization and to the school and to their families that need to be addressed. As far as ADHD, the ADHD comes back oftentimes, again, to the two areas of training that I think the previous question had. And that's where the focus needs to be. Making sure that teachers have the wherewithal to provide instructional strategies and motivational strategies by specific subject area to deal and exceptionality to deal with those students.
And Andy, let me say something. On the issue of autism, depending on the severity of the autism, one of the characteristics of that syndrome is great difficulty by those students in reading emotion in people. They misread it quite a bit. And so that can create a conflict that's not there that can be created because of that. And then with ADHD, one of the other problems with that is this is a condition that creates a great deal of frustration in people because you feel as if time is, what you feel is 10 minutes actually turns out to be 30. Time slows down. It feels like you're in slow motion, and that can be extremely frustrating to a child, and they lash out because of that. And so it's important to understand with violence and aggression how those play in. And the problem is that forensic criminal psychology has not met very well with special education training. I mean, we're one of the few, I think, in North America that actually teach how to blend the two together in an environment because we saw a long time ago as professionals that these critical issues needed to be addressed. So I think you have to understand, as Andy was saying, you have to understand the manifestation of those conditions and what they can create and what the perception is versus reality.
How you handle it as a school administrator and how you handle it as a school staff will oftentimes shape public perceptions and sentiments toward dealing with students with exceptionalities.
And any attorneys any plaintiff attorneys out there, you have to remember too that you need to know in your discovery process, okay, was criminal behavior or violent acts covered in detail in the training that was received by the special education staff or by the general staff or by the safety team. This is critical to know in defense of your client. So I just wanted to make sure we talked to both sides on this. But anyway, Matt, go ahead. I'm sorry, Andy.
You go to, again, with autistic students, many of them have stemming problems. And as a result of that, that is, in some circles, considered very, very disruptive, and that the student should be disciplined. Well, I just got done telling you what the rulings are as far as a student's behavior in school if it's determined to be part of his or her exceptionality. Well, stemming is part of the exceptionality of autism in many instances. So, how you handle that situation is very crucial in how the public then perceives it, shapes the opinion of how you address autistic students in your school and your community.
Matt, any other questions, Matt?
I don't see any other questions in the queue, so if you guys want to wrap it up here, I'll ask you guys.
Well, real quickly, a few seconds. Again, this is a complicated issue. It requires, from both sides who are listening today, it really requires that you understand its complexity and that you, from a school's perspective, a school district's perspective, really assess how well you're doing, not just in compliance, but in practical management on a daily basis, because that's how you avoid litigation. For those of you who are attorneys who litigate against school districts, there's a lot to do in discovery, in the prep of a case, in the beginning stages of a case, to understand what you need to do in discovery and setting up your interviews with witnesses to fully understand what goes on and what part the school district played in that process. So hopefully I know we just touched on this. We could go on for about 6 hours. It's a complicated subject, but hopefully it gives you some learning point to move forward as professionals. And we're available to talk to you all day today. If you want to reach out to Matt, we'll gladly call you back and we'll talk about whatever concerns you have. Okay? Thank you.
Thank you.
Excuse me.
Thank you, Andy and Dale. I thought it was a great presentation, and I know that our attendees found it very informative as well. If you'd like to speak to either Dale or Andy about a specific matter, you can call us here at TASA. Our 800 number is on the screen right now. It's 1-800-523-2319. We'll be sending out a link to the archive recording of this webinar later this afternoon. The email will contain the PowerPoint slides used during today's presentation. We post all of our archive recordings in the TASA Knowledge Center. I will send out a link as well to the TASA Knowledge Center. Our next client-focused webinar will be on June 1st, 2010. It'll be on the topic of understanding small business loans. We'll be sending out an invitation to that probably next week. So look in your inbox for that invitation. If you have any questions or comments about today's webinar, please feel free to contact me at mhyde@tasanet.com. We do use your comments to make the webinars better. We think that all comments are helpful to us as we develop these webinar series. So please feel free to contact me at any time. And like Dale said, if you would like to continue the discussion after the webinar, he and Andy are both available. Just contact me, either give me a call or send me an email, and I will get you in touch with them as soon as possible. I'm going to end the meeting right now. There'll be a survey that will pop up on your screen. Please take a couple minutes to complete that survey, and we hope to see you again soon at a TASA webinar. Thank you for your time. Thank you to Andy and Dale again.
Take care, everyone. Bye-bye.
Thank you, Matt. Thanks, everyone.
Yep, thank you.